If how to file bankruptcy without a lawyer was your last Google search, I see you, my friend. You're probably thinking two things. You're overwhelmed and broke. But before you DIY yourself through the legal system, let's talk about what's at stake and what could go wrong. Okay, so first things first. Is filing bankruptcy without a lawyer actually legal? Yes. Is it worthwhile? Maybe. Let's talk about it. Hi, I'm Adrienne Hines. You might know me on TikTok as the Ladylike Lawyer. Some people want to file bankruptcy without an attorney to save money. It's natural, right? It seems really unfair that you would have to pay money to get out of owing money. So in this video, I'll break down, are you allowed to file bankruptcy without a lawyer? And if so, what will you need to do it on your own? And why might it cost more in the long run? Oh, and how should you decide if this is right for you? Hmm. Well, let's start with the basics. Are you allowed to file bankruptcy in your state without an attorney? Yes, absolutely. You are allowed to do it in every single state. It's called filing pro se. That means filing bankruptcy without a lawyer. It's actually Latin and it translates to for oneself or on your own behalf. So if you're thinking about filing bankruptcy pro se, it's probably because of money. Wanting to file pro se makes total sense, especially if you're already broke. But how are you supposed to pay for a lawyer? It does feel like a catch-22. You can't afford to pay the bankruptcy because you're in debt. But now comes the big question. Is it really a good idea to file bankruptcy on your own? Well, we'll get into that in just a minute. But first, let's look at what you're probably most curious about, the cost. Specifically, how much does it cost to file for bankruptcy without a lawyer as compared to filing bankruptcy with one? The first things we need to talk about are the court filing fees. These are the costs that are set by the bankruptcy courts, and they're the same in every jurisdiction across the United States. It's $338 to file a Chapter 7, it's $313 to file a Chapter 13, plus you're required to take two courses, a credit counseling class and a debtor education class as part of your bankruptcy, and those are usually going to cost you $10 to $50. So filing on your own is going to cost you about $400 minimum. Now, in a Chapter 7, attorney's fees are somewhere around $1,000 to $2,000 and up. Remember, in a Chapter 7 bankruptcy, we're going to get rid of all of your qualified debt outright. So you add in the court fees and the credit counseling costs, which remember are about $400, and the total is going to depend on the going rate in your state. So for example, in California, the average cost to file a Chapter 7 bankruptcy is about $1,800. In Texas, it's around $1,600. And in a Chapter 13, attorney's fees are usually set by the courts based on your jurisdiction, typically $3,000 to $8,500. Remember, Chapter 13 is a restructuring of debt, so you pay off your debt over time. Your attorney's fees are part of this debt, meaning you're going to pay some of your attorney's fees over the course of that 3 to 5 years. So yes, you are going to save money if you file for bankruptcy pro se. But let's go beyond the cost savings and look at really the other pros and cons of filing on your own versus filing with an attorney. When you file pro se, you will need to handle everything yourself. That's all the paperwork. That's the credit counseling and the debtor education. You have to file with your federal court. You have to respond to your trustee. You have to appear for your bankruptcy hearing. And let's be real, bankruptcy is something that people go to law school to learn how to do. Me, I've been to undergrad and law school, and the learning curve is huge. The paperwork alone is not user-friendly, just to put it mildly. You're trying to manage federal law, state exemptions, court deadlines, financial disclosures. The paperwork also includes confusing forms like the means test, Form 122A-1, where you have to prove that your income qualifies, or Schedule C, where you list all of your assets, the things you want to keep using your state's exemptions. If you file the wrong version or fill them out incorrectly, you could lose something that you didn't have to lose. Unless you are extremely detail-oriented and you're able to navigate the legal system, there's a really good chance that you're going to make a mistake here. Honestly, filing bankruptcy on your own is a bit like trying to assemble IKEA furniture without the instructions. Like, while blindfolded, okay? I mean, sure, you can give it a whirl, but the chances are you're actually going to need those instructions pretty quickly into the process. And here's why. What happens if you miss a deadline? You could have to start over. What happens if you file the wrong chapter? You could end up stuck in a repayment plan when you could have just had a clean slate and walked away from your debt. What happens if you make a mistake listing your assets? You could get your case dismissed. You mess up your exemptions. You could very well lose something important to you. I once saw a young, unrepresented woman who thought she was going to save herself some money by filing bankruptcy on her own without a lawyer. I have to tell you that I watched her bankruptcy hearing, and by the time it was over, she owed her bankruptcy trustee over $10,000 because she didn't understand the rules, and you can't back yourself out of a Chapter 7 once you filed it. When you hire a lawyer, on the other hand, you're not just paying somebody to fill out your forms. A good bankruptcy lawyer is going to spot the red flags before the trustee does. That's really our job. We're going to help you protect your property. We're going to make sure your case doesn't get rejected on a technicality. We're going to guide you through everything from start to finish safely. So with that in mind, when does it make sense to file pro se? I would recommend that you have to hit 5 criteria to even think about filing on your own. The first, you have to be filing a Chapter 7 because Chapter 13 is just far too complicated to do on your own. Second, you have to have no assets. Otherwise, you risk losing something that you could have kept if you had hired a lawyer, like a house, a car, a boat. Number 3,
Your income has to be below your state's median income to qualify for Chapter 7 without jumping through extra hoops.
Number 4, you have to be extremely organized and confident you can navigate legal documents. Number 5, you've done your research and maybe you'd even gotten advice from a nonprofit, or you have access to free legal aid, which is often available through your county. Even then, we strongly recommend getting a consultation with a bankruptcy attorney first because there might be things that you haven't thought of that will make the process a lot smoother. For instance, here's what you might not have considered. Filing bankruptcy stops collections immediately. That means there's going to be no more wage garnishments, no more lawsuits, no more calls. Suddenly, boom, you have breathing room to hire an attorney, right? Most attorneys are going to offer payment plans, and many even offer pay after you file setups that work within your budget. So here's the deal. Yes, you can file without a bankruptcy lawyer, but should you? That really depends on your situation, your confidence, and how much risk you're willing to take. If you're even a little teeny bit unsure, you should talk to somebody who knows their stuff inside and out, right? I've dropped a link into the description where you can actually connect with a bankruptcy lawyer who offers flexible payment plans and zero judgment. Always zero judgment. Go check it out. You deserve real support, not guesswork.
Bankruptcy Explained.